All right, I'm just going to give it a minute as everyone trickles in. All right, the trickling has stopped, so we'll just begin. This is being recorded, though, so if any piece is missed, we can go back and look at it. It will be posted. My name is Stephen Smeltz. I am the hearing officer for this rulemaking, Class 6, docket number 241000246. This is a presentation stakeholder meeting, and I'm going to turn off my video and hand it over to Mr. Seeley and Ms. Mercer, and they will talk us through the slides. Um, I think people have the option to chat. If you have questions, you can drop them in the chat, and we'll kind of collect them and try and answer them at the end. Um, thank you.
Sounds great. Thank you, Stephen. And good afternoon, everyone. Welcome and thank you for joining us today. My name is Mark Seeley. I'm the lead CCUS specialist with the Colorado Energy and Management Commission. I'd first like to start off by saying thank you for your engagement and input. They've been essential to the development of our Class 6 rules, and we truly appreciate the time and effort that you've brought to the process. Joining me in today's presentation is Assistant Attorney General Lauren Mercer. Next slide, please. The agenda will cover the legal requirements for Class 6 rules, focusing on the comparison between Colorado law and EPA regulations. We'll then go over the rules in more detail, outlining what is specific to ECMC versus EPA. Next, we'll discuss our coordination with the EPA, both prior to and throughout this process. And then finally, I'll provide a high-level overview of the Class 6 permitting process and wrap up with details on the upcoming rulemaking session. As Stephen mentioned, we'll be taking questions at the end, so please enter any questions you have into the chat. Most of you know Mike Rigby. He's behind the scenes. We'll be looking at those and aggregating into themes as much as possible so that we can address them. If we're unable to cover all your questions today, we are happy to follow up individually at another time. So without further ado, thank you again, and let's hop into it. Lauren?
Thank you, Mark. And next slide, please. So good afternoon, everybody. For anyone who I haven't met yet, I'm Assistant Attorney General Lauren Mercer, and I'm representing ECMC staff in the Class 6 rulemaking. And I'm here today to talk about the unique legal constraints that impact this rulemaking, which was really our driving purpose behind getting this, one of the driving purposes behind getting this session together. Next slide, please. Next slide. Thanks. So if you attended our last stakeholder meeting, you've seen this slide before, but we just wanted to show it again because it does a nice job of breaking down the concept of carbon capture and sequestration, which we might also call CCS, into its three parts. So first, carbon dioxide is captured from the source, then it's transported to the injection site, typically by pipeline, and finally, it's injected deep underground for permanent storage. As folks are likely familiar, ECMC has only been granted jurisdiction over the last phase, the sequestration, and that's the limit of what ECMC's Class 6 rules can cover. There are other regulators that oversee the capture and the transportation of CO2, and those phases of CCS are outside the scope of this rulemaking. Next slide, please. So as I mentioned, this is a unique rulemaking for ECMC from a legal perspective. Typically, the only limits on the rules that the Commission can adopt come from Colorado law. And here we have several statutes on CCS enacted by the legislature over the past few years that provide very specific requirements that apply to this rulemaking. But additionally, we have the unique aspect here of the EPA's involvement. Because the goal of this rulemaking is to obtain primacy from the US EPA to regulate Class 6 wells, which are currently regulated by EPA and will remain so until Colorado gets primacy. Because of that tie-in, ECMC is also constrained by the EPA regulations. So this slide is just intended to show that the ECMC's Class 6 rules have a lot of aspects that are, I would say, kind of pre-baked in order to ensure we comply with both state and federal requirements. And there's thus, in our view, less discretion than the Commission typically has when adopting rules. Next slide, please. I'll briefly now go over the state regulatory requirements that we have to fulfill with these rules. Now, of course, this is not an exhaustive list. For the full statutory requirements, they can be found in the Energy and Carbon Management Act, specifically in 3460-106. But I'll review the major ones. So first is that Class 6 wells are required to have no net negative cumulative impact on a disproportionately impacted community. And now this is a novel standard for ECMC. It's a different legal standard than applies to operations outside of a disproportionately impacted community and different from the standards that we're all familiar with in oil and gas. And I think there's a lot of opportunity in this rulemaking to continue talking about what the no net negative cumulative impact standard means and how it should be applied. Staff's first attempt at addressing this standard can be found in Rule 1410D, and we look forward to continuing to discuss with stakeholders the ideal approach. Second is that the legislature adopted a hard 2,000-foot setback for Class 6 wells from residences, schools, and commercial buildings. This is, again, different from the oil and gas context, where ECMC adopted a presumptive 2,000-foot setback by rule, but there are various off-ramps. Here, the legislature gave us a hard setback, so we don't have off-ramps. Third, the statute requires ECMC to ensure that Class 6 operators provide financial assurance sufficient to comply with both the Act and the EPA requirements. To accomplish this, staff proposes to adopt the EPA financial responsibility rule in full with only very minor tweaks. This rule is very stringent, and Class 6 projects elsewhere in the country, just to give you some context, have required tens of millions of dollars in financial assurance to meet these requirements. So this is different from its Rule 1415. It's not the 700 series, which are the financial assurance rules that the Commission adopted for oil and gas last year. Fourth, a Commission hearing is required prior to issuing any Class 6 permits. Next slide, please. So next, ECMC's permitting must comply with the local government siting of the surface facilities. So it's yet another area where the legislature is requiring a different approach than we have in oil and gas, where the Commission just has to consider the local government siting but is not bound by it. Here, our ECMC siting needs to comply with the local government siting if the local government regulates the siting of these facilities. Sixth, I think we're at, ECMC must ensure that the geologic storage operator has obtained any air permits required by CDPHE. This is in Rule 1418H. Next, the surface owner consent is required for the surface facilities. And finally, that the Commission must evaluate and address the cumulative impacts of each project. And here, staff's draft leverages the rigorous rules that were adopted just last month in the cumulative impacts rulemaking, largely incorporating them by reference and ensuring that they apply to Class 6 projects. Some parties helpfully noted inconsistencies between the noticed Class 6 rules and the final cumulative impacts rules, and we really appreciate folks pointing those out. Staff's intent is for there to be consistency here, and so any inconsistencies there were really a result of the timing of noticing these rules before cumulative impacts had formally wrapped up. And so we aim to clean up any of those inconsistencies in the next draft. Next slide, please. Now on to EPA's legal requirements. So as this group is familiar, EPA has lengthy and highly stringent regulations governing Class 6 injection wells, or UIC, underground injection control wells. And now to obtain primacy, ECMC is required by federal law to adopt rules that are at least as stringent as those federal rules. And to meet that stringency standard, EPA has encouraged ECMC to adopt the federal regulations as closely as possible. In my view, this is the biggest limitation on the rulemaking in terms of putting some guardrails on what we're able to do here. Next slide, please. We thought it might be helpful to clarify which of the noticed rules are EPA regulations, which we're required to adopt as closely as possible, and which ones are Colorado-specific rules that we put into place to comply with Colorado requirements. And in this rulemaking, I'd say the difference is that ECMC has the usual discretion that it would have to revise the Colorado-specific rules, things like procedural issues, but we're much more limited in that discretion when it comes to the EPA rules. That's why we thought it might be helpful to make it clear which rules fall into which category so that stakeholders can target their feedback on the rules accordingly. Next slide, please. So there's roughly a 2/3 to 1/3 breakdown of EPA rules versus ECMC rules in our draft. As a very sort of general proposition, the federal rules cover the technical downhole requirements, while ECMC's rules cover surface siting, the permitting process, and interactions with local governments, as well as cumulative impacts and considerations for disproportionately impacted communities. Next slide, please. So the definitions, we recognize that there are a lot of definitions in the draft rules, and they're pretty much or largely driven by EPA regulations that we are required to adopt and new definitions that came to us from Colorado statute. They're split pretty evenly in terms of the source and listed here. And we will be filing this presentation into the docket, so parties will have access to it. You don't need to be scribbling all these down right now. Next slide. So now on to which of the rules are specifically required by EPA. And so we're drafted to align as closely as possible with EPA regulations. As you can see from the list on the slide, there are quite a few general rules and rules related to the permitting process that we took straight from EPA. Next slide. And here's, in my view, where we really get into the meat of the EPA regulations. So there are siting criteria that are related to the subsurface formation, so minimum criteria, characteristics of the reservoir that can be proposed for Class 6 injection. And then we also are including nearly verbatim the EPA regulations for area of review and corrective action, financial responsibility, and the wellbore construction and operations, which there are quite a few pretty meaty technical rules under that category. Next slide, please. The same goes for reporting and compliance, post-injection site care and site closure, emergency and remedial response, injection depth waivers, and the requirements to transition from Class 2 to Class 6. So those are all of, or at least the bulk of the very technical rules of, the technical requirements that will apply to these operations. Really, we tried to take as verbatim as possible from EPA because that's what they require to ensure that we meet their stringency. Next slide, please. And now I'll talk about the Colorado specific rules in the draft. As shown here, there are general rules in the 200 and 500 series that apply to Class 6. The other one I'd throw in the general category is the applicability rule, where some of that rule comes from EPA when it talks about the subsurface, or I'm sorry, I'm getting lost. But there's some of those that come from EPA. But what ECMC specifically added were rules regarding when these regulations will go into effect, which is upon obtaining primacy, and also how we are going to handle permits in Colorado that are issued from EPA before ECMC gets primacy, because there needs to be some sort of process for transferring them over to ECMC. Then we've got the application and permitting process rules, and these are really the bulk of the ECMC rules in the draft. Here we modeled the permitting, notice, consultation, and public participation processes on existing ECMC process, really leveraging the work that was done on a lot of those items, again, in the cumulative impacts rulemaking, to make sure that they're up to date and cover the sort of full public process that folks have come to expect at ECMC. There are also some sort of specific requirements in there to make sure we are in compliance with the statutory requirements in Colorado for Class 6. And then Rule 1410 is a big one that is an ECMC rule specific to cumulative impacts and disproportionately impacted communities. Next slide. And on this slide, you'll see that there are specific subsections of two of EPA's technical rules that contain unique ECMC requirements. That's in 1411C and 1420L. However, the bulk of those rules, 1411 and 1420, are EPA language. It's really just those subsections that ECMC added to. And then at the end, we've got our related regulatory requirements that are unique to ECMC. So that's 616 for drilling other wells through or adjacent to a geologic storage facility, requirements for science and monitoring wells, unitization, and the various other ECMC rule sets that will apply to Class 6. So I know that was fast, but folks will have these slides after the fact to digest. And as Mark said, we're happy to take questions. And with that, I will hand it back to Mark to talk about our process so far with EPA.
Thank you, Lauren. Next slide, please. And actually, we'll do one more slide, please, Stephen. Thank you so much. So as we work towards primacy for Class 6 wells, we understand that effective and consistent communication and coordination with EPA is extremely important. I want to point out that we have established regular communication on an ongoing basis, as our team regularly meets with EPA about twice a month. These regular check-ins are part of both of our agencies' commitments for transparency with each other, as well as just being proactive in our communication. In addition to these meetings, we have been present at several key conferences throughout the year, where we've discussed Class 6 regulations and the primacy process. These events allow us additional dialogue with EPA and help us understand emerging federal expectations. A significant milestone was releasing our straw dog draft rules in early July. And this draft was the basis for the EPA's crosswalk review, both from the EPA headquarters as well as from the EPA Region 8. I would like to take this opportunity to thank EPA for their timeliness, responsiveness, and collaboration as we've advanced through our rulemaking process. They've been really great to work with. As the review process progressed, our coordination with EPA shifted to weekly meetings starting in September. The goal was to make these interactions more frequent, enabling us to respond to feedback and coordinate more in real time. Toward the end of October, we reached another critical point in our coordination. We received comments on our crosswalk from both EPA headquarters as well as the region. This feedback highlighted areas for further review and provided more clarity on EPA's expectations. Using this feedback and the notice draft rules, as well as stakeholder feedback, we just created an updated crosswalk that we shared with EPA on Monday, and we're expecting additional feedback sometime next week. Ultimately, our consistent engagement with EPA, I hope, reflects our commitment to building regulations that are both thorough and in close alignment with federal requirements, and will remain a priority as we move throughout this process. And now I'll hand it back to Lauren for the next slide.
Thank you, Mark. So one of the reasons we wanted to talk to folks today was to talk through the crosswalk, which this is one of the items that staff filed in the docket on Tuesday. So hopefully everyone here who's a party received it. And it's, to put it mildly, a pretty complicated document that is sort of hard to understand until you know what you're looking at. So we wanted to sort of walk folks through it together to try to make it as readable as possible. So the crosswalk is really the primary way that ECMC and EPA go back and forth about determining whether our regulations in the draft rules are at least as stringent as the EPA regulations. It's a standard form that EPA uses for every state that applies for primacy, and it's a good collaborative process, but it looks a little messy from the outside. So what we have here, this is a screenshot of just the first page of the crosswalk, and the columns going from left to right. The first two, so we've got the federal requirement, which is the text of the applicable federal regulation. Next to it in the federal citation column is just the citation to the place in the Code of Federal Regulations where that language can be found. So there's a row like this for every single federal regulation, every single subsection that we're required to adopt or have rules that mirror. And these first two columns came preloaded from EPA. So that's sort of what it came with. And then when you get to that middle column, the state citation and regulatory text, that is the column where ECMC was required to go through and put in what from our rules do we believe matches the requirement on the federal side. So line for line, where do things match up? You'll see in a lot of these, this column, a lot of track changes because we put in our sort of initial take. Then EPA took a look and went in and in a lot of cases added the full text of the provision that we're referencing that they think applies, or they think is at least as stringent or equivalent. And then this all happened sort of on the front end using the straw dog draft, because our goal was to get EPA's eyes on the draft rules as quickly as possible and not wait until the notice draft, knowing we were aiming to have a pretty solid straw dog draft. So then some of what you'll see in red line in this column is where we went in and put red lines to show how that state provision changed between the straw dog and the notice draft. So what you see here, for instance, the text that's in purple, I think, is what was in the straw dog, and what's in blue is what was added since then. The next column says different from federal requirement, and that's where EPA headquarters did a full line-by-line review to go through, look at the federal regulation, look at our regulation, and determine whether we, copied and pasted the exact text, whether there were minor changes or significant ones, and then note, like here it says intent is similar. That's them sort of being okay with it, is how I read that. Then the next column is feedback from EPA Region 8, which that's the region that includes Colorado. So we have the headquarters, which is in DC, and then Region 8. Region 8 reviewed after headquarters did and added any additional comments they had. In the far right column, ECMC update, that's where this last time we sent the crosswalk back to EPA, we did two things. First was try to clarify any changes that were made between the straw dog draft and the most recent draft that we shared with EPA, which was the noticed draft plus a handful of changes that we had already started to make in response to earlier feedback we got from EPA. So it's mostly the notice draft, but not exactly, which I know further complicates things. So in this column, we explained any of those changes that were made, and then also made sure that we provided an answer to any sort of question, comment, or concern raised in those first two columns. So hopefully that overview helps folks as you're trying to understand this document, and we're available if there are further questions. Mark, I will hand it back to you, and if you have any further clarification on what I just said, I'm sure folks would welcome it.
No, Lauren, I thought that was great. It's just a very detailed document to walk through. And as Lauren mentioned, if anybody has questions, feel free to reach out. Happy to address any and talk through stuff as appropriate. Next slide, please. Actually, one more, please. So I'd like to give an overview of kind of the Class 6 permitting process that we have outlined. I wanted to provide the rules that kind of govern each stage. We're first going to start on the far left-hand side. I'm not going to spend a lot of time to talk about it, but Rule 1401, 1403, and 1426 govern kind of existing wellbores to be drilled prior to converting to Class 6, including science wells. Again, I'm not going to spend a lot of time talking about that today, but happy to talk about that offline with folks if they'd like. What I really want to focus on is Rule 1405 and 1406, basically everything to the right of that first box. So the Class 6 development plan process really begins with a pre-application meeting, a step that brings together relevant local governments or federal agencies, ourselves, ECMC, CDPHE, CPW, and if the proposed location falls within the DI community, a community liaison. The applicant is also required to hold a pre-application community meeting. These initial meetings allow all parties, including the community, to discuss any concerns and gain a clear understanding of the project right from the start. One of our primary goals throughout the permitting process is to be deliberate in our notifications and to consider all stakeholders who may be impacted from the proposed project. Following the pre-application step, the applicant will submit a Class 6 development plan. ECMC staff will conduct a thorough review to confirm that all required information is provided, and then proceed with a technical assessment to ensure the application complies with our regulations and is viable to become a Class 6 project. If the application is complete, meets technical and regulatory requirements, ECMC staff will issue a notice of completeness. Along with this notice, we will prepare a fact sheet that summarizes the project, and notifications will be sent out to relevant stakeholders. I will note that this step is comparable to what the EPA calls a draft permit. This step also initiates the main stage that serves as an opportunity for the public to review the project and submit comments. After the public comment period closes, the director, ECMC, will review and issue their findings. The permit will advance then to a commission hearing, and the commission will make a formal determination of the permit. Please note where notifications will be sent for each stage of the process, which we'd love feedback if that's too little or too much, but we're just trying to make sure at each main stage gate that everybody is fully aware of where things stand. If the commission approves the Class 6 development plan, the applicant gains authorization to construct the well. However, it's important to note that injection activities cannot commence at this stage. To move forward with injection, the applicant must first provide site-specific and subsurface site-specific data if it has not already submitted it. ECMC staff will review this data to determine whether an authorization to inject can be granted, and only upon this final authorization can the operator begin injection activities. So hopefully this provides a little visual representation of what could be a complex process. Next slide, please. Thank you. This is the final slide that we really have just to kind of outline the go forward rulemaking process. I will highlight that we do anticipate releasing a second draft in the middle of next week. November 20th is our goal. And then we will roll into the Thanksgiving holiday and prepare for the rulemaking set to begin the beginning of December. So with that concludes our formal part of the presentation. And I think we can now open it up for questions, or if there's any additional comments that Mike, you would like to make, or Ben Boudreau, or other AAG is also on the line.
I don't have anything to add. I can address some of the questions that have come in, unless Ben, if you have anything to add.
No, I don't.
One of the first question is asking if the setback pertains to facilities or wellheads, and the statutory requirement in Colorado law is that the 2,000-foot setback is from the well, so the wellhead, and can only be there is a caveat to that it could be adjusted by rule only after 4 projects have been operating for 4 years. The second question is, will we be assigning essentially maximum allowable injection pressures? And while we're not necessarily assigning them, we'd be approving them in that step that Mark pointed out. If you went to maybe back to the process slide, back one, be more easily seen. But essentially during that authorization to inject, in the case where you get the approved Class 6 development plan, you can construct your well, you can gather additional data in the well that would be specific to that wellbore and that formation that could be acquired prior if you drill the science well. But in the case that you didn't, you would get authorization to construct, gather additional wellbore specific data that's required by federal regulation, submit that in a subsequent form, and that would go into determining the exact maximum allowable injection pressure. Any other questions?
I think there's one that I see talking about, is there an estimated timeline for a permitting timeline, much like EPA? I know EPA has a dashboard that shows where permits are during their process. And I would envision we are going to have something very similar. To estimate what those timeframes are, I think is premature now. The technical review, I believe EPA currently has 18 months as their timeframe, and our goal is to beat that and beat that pretty handily. I'm not ready to commit to specific timelines right now.
Oh, one more question popped up. Two more questions.
Sure. So the one question is how we will address pending applications before the EPA currently undergoing technical review. How will they be transitioned prospectively to ECMC upon delegation of primacy? So and I'll let Lauren or Mark add on to what I'm about to say, but our rules do initially contemplate this. We're definitely happy to take feedback on that and work with stakeholders on exactly how that process should be outlined in the rules. I will say, even outside of the rules, we're already discussing with the EPA and considering how best to expedite this process to make it as seamless as possible, and plan to start work, once our primacy application is filed next year. We plan to start working closely with them to make this process work effectively, so that day one, when primacy is transferred to the state, that there isn't a large delay in progressing these through the process. I think we definitely should outline and have initially outlined a rule that structures some of these items within our rules, but some of this will be done in our collaboration with the EPA, and it is a topic that is already being discussed between ECMC and EPA. I don't know if Lauren or Mark want to add anything there.
All I'd add is that, of course, we welcome conversations about that because it is something we want to make sure we get right. So we're open for individual conversations throughout this process. So please reach out if there's something you want to talk about.
The next question is about the monitoring well leak of the ADM. The ADM monitoring well leaked in Illinois, and are we addressing that it leaked? There are extensive monitoring requirements and reporting requirements. So I do think, but that is a particular scenario. And there has been guidance updated from the federal level to the regions on that particular well leak and what caused it. Quite frankly, to learn lessons across the nation as these progress. And, in particularly, I think there's concerns with the exact type of steel used in that scenario with that exact type of fluid stream that was present in that well. So we are very aware of it, have been following what has happened, and beyond that, I don't have much comment on that well bore. Mark or Lauren or Ben?
I think that's fair. I think it's just important that, the well construction materials, cement as well as casing, it has the right metallurgy and composition to handle the subsurface fluids. It's just be something we need to, I believe, continue to be diligent about in Colorado.
Have you contemplated monitoring requirements for CO2 leaking in the atmosphere? I do believe that the testing and monitoring plans at the federal level and the ones that we've incorporated into our rules are structured to provide a regulatory framework to monitor really any kind of leakage, even within the subsurface, and definitely any making it all the way to the surface. I don't know if Mark or anyone else wants to add detail there. There are quite extensive monitoring requirements and an ongoing testing and monitoring plan that is required to be updated regularly based on technical parameters of the specific project.
Nothing to add.
I would add not to that. You covered it well. There was a question earlier that was more of a comment expressing frustration with the timing of this session and getting more information at this point. I just wanted to say we hear you. We're trying to provide as much information as we can, sort of as quickly as we can through this process. We heard last week, I believe, that folks were feeling like they were not getting enough information about the process with EPA. So that's why we put this session together as quick as we could. So I know that may or may not be satisfying, but we hear you and we're trying to be as responsive as possible.
Thanks, Lauren. I'm not seeing any more questions. Is anybody else seeing any?
I'm not, but we can definitely maybe give another minute here, see if any other questions from the attendees.
Sounds good.
I think as Lauren and Mark have said a few times, we're happy to have discussions. And if there's particular items you'd like to talk through, you can definitely reach out.
One more question popped up from Ms. Merlin.
2,000-foot setback from the well pad. You meant wellhead. Can you explain why you interpret this as a maximum? I believe I'm not quite getting that question. The 2,000-foot setback is the closest distance you could be to residence, school, or commercial building with the wellhead per the state law. Is there something else that you were asking beyond that? Maybe I misspoke and I apologize for that. So hopefully that clarified it.
All right. I think if there's nothing else coming in, then we'll officially end this session. As we've mentioned throughout, happy to get together individually and talk through any concerns or questions or comments that folks have. Feel free to reach out to myself or Mike or Lauren, or yeah, we'll look forward to it. Any other comments from the panel?
Thanks everyone for making the time. As been noted, this has been recorded and the presentation will be e-filed. So you'll have an opportunity to review this again. Thank you.
All right. Everybody have a great afternoon.